We begin our report with a ruling from the Supreme Court that could make it easier for state lawmakers to design elections in their favor. The High Court rejected a challenge by civil rights groups who charged that South Carolina's recently redrawn congressional map was designed to hurt black voters. The state's Republican legislature drew the geographical boundaries that determine representation so that black neighborhoods were not included in a key swing district. A lower court said the move resulted in the, quote, bleaching of African-American voters from the district. But it was appealed to the Supreme Court, who, in a 6-3 vote, ruled the challengers failed to prove that race drove the redistricting process as opposed to politics. The new map breaks up Charleston County to solidify the once swing district as a Republican stronghold. South Carolina, which has 7 congressional districts, only has 1 majority black district, despite black people making up 25% of the state. CBS News legal contributor and Loyola Law School professor Jessica Levinson joins me now. Jessica, how is the case, let's step back for a moment. In this case, what is at issue essentially that states get to determine their voting patterns, but the federal government has a role to play if they decide that those voting patterns are racist or somehow inequitable? Is that essentially the big category we're in here?
That is exactly the big category we're in. Under the Constitution, states get to set the time, place, and manner of elections. But, and there's a big but here, the federal government has a role to play. We have the 14th Amendment, which talks about protecting the equal protection under the law, saying no state shall deny the equal protection. We know that has force when it comes to voting. And we're also talking about that hallmark piece of civil rights legislation, the Voting Rights Act. And so for both of those reasons, federal courts can, although increasingly they don't, step in and say, state lawmakers, you went too far. You're not allowed to draw district lines in a way that, for instance, dilutes votes on the basis of race.
Now, that's the key thing. So if I'm if I'm a member of the legislature, I can draw lines that increase my political power. I can do it for raw political power reasons. That's okay, right? But I can do that, but I can't do it if it's based on race.
Well, and John, as you know, Justice Alito began the majority opinion by saying, remember, partisan gerrymandering, which is what you just talked about, where you draw district lines to maintain or increase power based on partisan considerations, that's fine. And the Supreme Court a number of years ago said, in fact, federal courts have no role to play when it comes to partisan gerrymandering. We can't figure out which standard to use. Federal judges have to leave those types of considerations to state lawmakers and state constitutions. But then the question becomes, and John, you know this, how do you decouple two things that are often inextricably intertwined? So when is race a proxy for partisan affiliation? When are we trying to make sure that we get Democratic voters versus when are we harming voters on the basis of their race? It's really difficult to disentangle those two things.
Exactly. So how is this case that was brought before the court on the South Carolina question different from the one we saw from Alabama, where there was a 5-4 majority ruling that the state had violated the Voting Rights Act?
So I think what we see in the difference here is that Alabama just was not nearly as good about doing what they wanted to do, that Alabama's lines were, frankly, I think, more egregious. And Alabama's lawyers, I'm going to offer, were not nearly as good at convincing, particularly the Chief Justice of the United States, that those lines were drawn for a good reason. I think, John, you and I talked, I think, the night that the Alabama decision came out, and I said, don't mistake this as Chief Justice John Roberts or the conservative majority suddenly being in favor of more robust voting rights. It's just that they don't like this case. They don't like these lines. They don't like this attorney. And here's the next case with better lines, and I would offer better attorneys as well.
Excellent. Jessica Levinson, thank you as always.